If you were just in a crash, the mistake that hurts your case most may not happen at the scene. It may happen later when your phone rings and a friendly insurance adjuster says they just need your side of the story. That call sounds routine. But in real accident claims, that conversation often becomes the moment a case starts losing value. One sentence said too early, one guess about speed, one apology made out of politeness, one comment like, "I'm probably okay," and suddenly the insurance company has words it can use to question your injuries or your right to recover money. Meanwhile, you are still stressed and trying to understand what happened. If you have been wondering whether you need to talk to insurance after an accident, this video will give you the answer and show you how to protect yourself. I'm a practicing personal injury attorney, and I handle accident cases like this every day. I talk to people right after wrecks, when they are hurting, missing work, and getting insurance calls before they know how badly they are injured. By the end of this video, you will know why insurance companies push for quick statements, what they are actually listening for, when you do have to report a claim, when you should slow the conversation down, and what to say instead so you do not accidentally undermine your own case. The first thing you need to understand is that insurance companies are not calling to build the strongest claim for you. They are calling to protect their side. Adjusters may sound professional, but their job is still to investigate the claim and control how much money gets paid. In plain English, that first conversation is often a fact-finding interview. They want details about how the crash happened, what you felt right away, whether you think you contributed, and whether you had similar pain before the accident. They may also ask for a recorded statement, which is simply an audio recording of your answers that can later be reviewed and used against you. Imagine you are driving home from work, another car runs a red light and slams into your driver's side door. At the scene, your adrenaline is pumping and you tell the officer, "I think I'm okay." The next morning, your neck and back are hurting. Before you even get to urgent care, the insurance adjuster calls and says, "I just need 10 minutes. You say you did not see the other car until the last second. You say you might have been going around the speed limit. You repeat that you thought you were okay at first. What most people do wrong is treating that call like a casual chat instead of evidence. They guess, they fill in blanks, they volunteer possibilities they are not sure about. What you should know is simple. You usually do not owe the other driver's insurance company an immediate recorded statement just because they ask for one. If it is your own insurer, your policy may require notice and cooperation, but even then, you can still be careful, truthful, and limited. The safest approach is to give basic identifying information, confirm that the accident happened, and say that you are still being evaluated and are not ready to give a detailed statement yet. The second major point is that early statements about your physical condition can be used against you long after the pain shows up. Many people think an injury is obvious the moment it happens. In reality, many soft tissue injuries, concussion symptoms, and back problems do not fully appear until hours or days later. That is medicine. After a collision, your body is flooded with stress hormones. Adrenaline can mask pain. Shock can make you focus on getting home or dealing with the damaged car instead of noticing what is happening in your neck, shoulder, back, or head. So when people say, "I'm okay," they often mean, "I don't know yet." Insurance companies know that, but they will still use the earlier phrase if it helps them minimize the claim. Picture this. You are rear-ended at a stoplight. Your bumper is crushed, but you walk away. The adjuster calls that afternoon and asks, "Were you injured at the scene?" You say, "Not really." 2 days later, you wake up with intense lower back pain shooting into your leg. An MRI, which is a scan that shows soft tissues and discs, later reveals a disc problem. Now the insurance company points to your earlier statement and argues that the injury must not be related to the crash, or at least not as serious as you claim. What most people do wrong here is speaking in absolutes. They say, "I was not hurt," or "I'm fine," because they want to sound honest. But those words can turn a temporary impression into a permanent record. What matters legally is evidence, timing, and credibility. Your job is not to sound dramatic. Your job is to be accurate. If you do not know the full extent of your injuries, say exactly that. A better response is, "I'm still being evaluated," or "I did not understand the full extent of my symptoms at the scene." Then get medical care promptly. Gaps in treatment give the insurance company room to argue that you were not truly hurt or that something else caused the problem. The third thing you need to know is that fault is often decided through evidence, not through whatever polite thing came out of your mouth under stress. People apologize automatically and speculate. Unfortunately, those instincts can create real problems. Fault means responsibility for causing the accident. In some states, if you are found partly at fault, your compensation can be reduced. In other states, even a small percentage of fault can affect whether you recover anything at all. Imagine you are moving through an intersection on a green light. Another driver turns left in front of you. The impact happens fast. You get out, shaken, and say, "I'm sorry, I didn't even see you." You mean, "I'm sorry this happened." The other side hears, "I admit I caused this." Later, the adjuster asks whether you might have been distracted. You say, "Maybe for a second I was looking at traffic." Now a human reaction has turned into an argument that you were not attentive. Here is where most people go wrong. They think honesty means answering every question immediately, even when the question asks them to estimate distance, speed, reaction time, visibility, or what another driver was thinking. But a guess is not honesty. A guess is uncertainty dressed up as confidence. What you should do instead is stick to facts you actually know. You can say where you were, what direction you were traveling, what light you had, where the damage appears, whether police responded, and whether there were witnesses. You should not guess about miles per hour, stopping distance, or what another driver could have done unless you truly know. And you do not need to apologize for the accident just to sound decent. You can be respectful without accepting blame. The fourth key point is that the most dangerous insurance conversation is often the one that sounds like good news. That is the quick settlement call. This is when the adjuster offers fast money before you know the value of your claim, and sometimes before treatment is finished. A settlement is the final agreement that ends the claim in exchange for money. A release is the document you sign giving up your right to ask for more later. Once that release is signed, the case is usually over. That is true even if your pain gets worse, you need more treatment, miss more work, or your doctor later finds a more serious injury. Imagine you missed 2 days of work after a crash. The other driver's insurer calls and offers a check for what sounds like a decent amount. They say they want to help you move on quickly. Your car needs repairs, rent is due, and you are worried about lost income, so the offer feels like relief. Then 3 weeks later, you learn you need physical therapy for months. But the release is already signed. What most people do wrong is focusing only on what they need today. That is understandable. Bills do not wait. But insurance companies know financial pressure makes early offers tempting, especially when someone has not yet talked to a lawyer or doctor about long-term effects. What the law may allow you to recover can include medical bills, lost income, future treatment, pain and suffering, and other damages depending on your state and facts. Damages simply means the losses the law may compensate. You cannot value that honestly on day 2. So if an adjuster wants a recorded statement, a medical authorization that gives broad access to your private history, or a fast release, slow down. Review everything carefully, and if the injuries are more than truly minor, get legal advice before you sign. Here is where things go wrong for a lot of people. The first mistake is believing that being cooperative means being unguarded. Most people do not realize you can be polite and still protect yourself. They think saying less makes them look suspicious. In reality, a short, accurate statement is safer than a long conversation full of guesses and unnecessary details. The second mistake is signing forms they do not understand because the paperwork looks routine. Most people do not realize that a medical authorization can sometimes give the insurance company access to years of records that have little to do with the crash. If you hurt your back in this accident, they may go digging for an old gym injury, a chiropractic visit from years ago, or a complaint in your primary care notes that they can use to argue your condition was pre-existing. Pre-existing just means it was there before. That does not automatically defeat your claim, but it changes how the claim gets argued. The third mistake is waiting too long to document what happened because they assume the facts will stay clear. Here is what people forget. Bruises fade, vehicles get repaired, skid marks disappear, witnesses stop answering unknown numbers. Even your own memory changes faster than you think. Most people tell themselves they will organize everything later. But in injury cases, early documentation is power. Photos, medical visits, names of witnesses, the police report number, and a written summary of how your symptoms evolved can make the difference between a disputed claim and a clear one. The insurance company starts building its file right away. You need to start building yours too. So what should you do if insurance calls after an accident? First, take a breath and slow the conversation down. You do not have to match their urgency. Get the caller's name, company, phone number, claim number, and ask whether they are calling from your insurer or the other driver's insurer. Then, report the crash to your own insurance company if your policy requires notice, but keep your description factual and basic. Tell them when and where the collision happened, the vehicles involved, and whether you are seeking medical evaluation. If you do not know an answer, say you do not know. The third thing most people skip is getting medical care quickly when symptoms appear, even if they seemed minor at first. Follow up with the right provider, follow the treatment plan, and be honest about your symptoms. Next, preserve evidence. Save photos, repair estimates, tow bills, prescriptions, discharge papers, and messages from insurance. Write down how your injuries affect sleep, work, driving, lifting, and daily life while it is fresh. After that, do not give a recorded statement to the other driver's insurance company until you understand your injuries, and if the case is more than minor, until you get legal advice. Finally, do not sign releases or broad medical authorizations just because someone says it will speed things up. Fast is not always fair. Careful helps. If you are dealing with this right now, I know it is stressful. You are trying to heal, manage your car, handle work, and make good decisions while people ask for answers before you have them. Watching this and learning your rights is a smart move. If you have questions, drop them in the comments and I'll cover as many as I can. If you want plain English legal education like this every week, subscribe to the channel. And if you have a specific accident situation, feel free to reach out for a consultation. You do not have to figure this out alone, and the more informed you are, the harder it is for anyone to take advantage of you.